Good morning, everyone. I think we'll get started. My name is Elisa Scally. I am a partner with Gowling WLG, practicing in the Ottawa office as part of the Employment, Labor, and Equities Group. I'd like to welcome you this morning to the first of our six-part webinar series on employment law. As you know, today's topic will focus on ensuring that you have all the information you need to be compliant with the AODA filing deadline, which is coming up at the end of June. Our speakers today are Nina Gupta and Shefali Rajaputra. Nina is a partner in the Gowling WLG Waterloo office, where she has a broad employment and human rights practice. She is the firm's go-to for all AODA matters. She's known for her pragmatic and plain language approach to complex legal issues. She is also the chair of our Diversity and Inclusion Council. She's been repeatedly recognized by Lexpert and Best Lawyers for her excellence in employment and human rights law. I'm sure many of you have heard her speak before because she's a very popular and informative speaker on a variety of topics. She's also a published author on matters relating to employment contracts, wrongful dismissal, and human rights investigations. Nina is a mother of a wonderful teenager, and she's also the grandmother to a 500-kilo horse, whom she considers her fur grandchild. Shefali is an associate lawyer in Gowling's Waterloo office. Her practice also focuses mainly on employment law. She works closely with Nina on AODA issues. She has considerable hands-on experience advising employers on a broad range of workplace matters, from employment contracts, terminations, and enforcement of restrictive covenants. She regularly assists her clients with reviewing their workplace policies and procedures. She's qualified to practice law in Ontario and India. She is also known for her pragmatic approach and provides high quality advice to her clients. She's an avid animal lover and loves teaching new tricks to her two adorable fur babies, Chaos and Thor. Before we get started, I'd just like to mention that we will have an opportunity to have a question and answer session. So please leave your questions in the question box, and we will try to address your questions before the conclusion of the session. So now I'd like to hand it over to Nina.
Thank you, Elisa, and welcome everyone. So what I'd like to do is tell you what the agenda is, and also tell you a little bit about what we are and are not going. So if we could advance to the agenda slide, please. So I want to essentially do a brief overview of the AODA, including making sure you understand what parts of the legislation apply to your business. The AODA actually has some important regulations, and the most important for today's day will be the Integrated Accessibility Standard. And we will review the obligations under that standard. There is a big emphasis in the AODA on having the right policies and the right training of your employees. So we're going to review your training obligations. Now, as Elisa's already alluded to, there's a compliance report coming up. So we're going to actually go in some detail about your compliance obligations and how that report works, and briefly some of the consequences of non-compliance. It's also important to know what this session is not about. It actually will not give you the training that is mandated under the AODA. We do have different seminars with respect to the actual training that's required, but today we are trying to really tell business owners, HR professionals, in-house legal counsel about what they need to do for compliance in their entire organization. So it's really more learning about the AODA rather than taking the mandated training under the AODA. So why are we doing this now? Well, as you can see on the next slide, we're doing it because a filing deadline is coming up on June 30th, 2021. This filing deadline is an extension because it was originally due December 31st, 2020. The Ontario government was actually lobbied to get rid of that filing obligation, but felt that that would be inappropriate and gave a 6-month extension unilaterally to all businesses with a filing obligation. There's no sense that that's going to be extended again. So all of us should be prepared for that June 30th, 2021 deadline. By the way, please don't leave it to Wednesday, June 30th. Last time there was a filing deadline, everybody filed on the last day, December 31st, 2017, and the servers crashed, and it took us months to figure out whose filing had been accepted and whose had not. So if you can get it done early, you get brownie points, just like in high school. So what are we going to do next? We are going to do a brief overview of the AODA as a structure. So whether your obligation is one employee in Ontario or thousands of employees in Ontario, you do have obligations under the AODA. And this is a philosophical choice that the government of Ontario has made, which is to open up our economy, our businesses, our services, our government itself to employees, customer, and citizens with disabilities. The big goal was to make Ontario fully accessible by 2025. That goal was set in 2005 and seemed like such a long time, 20 years. We are fast approaching 2025, and I think in general, we would agree we've made progress, but there is a long way to go. So I'd like to essentially turn it over to Shefali, who's going to actually handle the next section about the AODA and how you understand your own obligations under that legislation. Shefali?
Yeah, thank you, Nina. Hello, everyone. I hope everybody is doing well on this lovely sunny morning. Well, at least it's sunny where I am. So as Nina alluded to, I'm going to be spending the next few minutes talking about the basics of AODA. And that is whether your organization is small or large, attracting every potential candidate for employment and customers is essential to business. And being accessible to potential candidates and employees with our customers with disabilities isn't just the right thing to do, it's also the law. And that law is the AODA. That is the topic of our discussion for today's seminar. And as Nina said, this law has been passed in 2005, so it's not new anymore. It's been there for over 16 years. And unfortunately, there are still businesses who are trying to get their feet under and trying to figure out their obligations under this wonderful legislation, which seeks to remove barriers and develops and helps put together processes for developing, implementing, and enforcing accessibility standards. So the AODA and the accessibility standards help to reduce and remove barriers and make Ontario more inclusive for everyone. Moving on to the next slide. Okay, so let's look at the Ontario Human Rights Code and how that works in conjunction with the AODA. So the goal of AODA is not to replace the obligations that several service providers and organizations have under the Human Rights Code, but what it does is that it works hand in hand with those obligations from the Human Rights Code. So the Human Rights Code focuses on non-discrimination, and the fundamental underlying principle is accommodation. Accommodation to people, accommodate people to the point of undue hardship. And how AODA beautifully lines up with that foundation is that it helps to reduce and remove barriers by providing a framework for organizations as to how to put it together in a succinct way so that all parties involved have an understanding of their obligations to make that practice more comfortable for everybody who's involved. So the goal for Ontario Human Rights Code, along with the AODA, is to really maintain the dignity of the persons with disabilities, as well as increase their independence, provide equal opportunity and integration within the society. Now, with that, let's look at who has to comply with AODA. So if your organization, regardless of whether it's public, private, or nonprofit organization, you have at least one employee physically located in Ontario, and you provide goods, services, or facilities to the public or to other organizations, then your organization is subject to the AODA. And important aspect is a lot of clients or a lot of organizations have this question: how do I count my employees? Who is included when you say employees? Well, first things first, employees outside of Ontario are not counted. You do not count volunteers, and you definitely do not count independent contractors. So if you have just independent contractors with your organization in Ontario, then the obligations under AODA wouldn't apply. It would start to apply the minute you hire your first employee who's physically located in Ontario. And there are different classes to which the AODA applies. It applies to the Government of Ontario and the Legislative Assembly, applies to large designated public sector organizations with 50 and above employees, as well as small designated public sector organizations with under 49 employees. And most importantly, applies to large and small private organizations with 1 to 49 and 50 plus employees. Well, the reason why we specifically spell out the number is because the requirements for compliance under AODA depend on the class and the number of employees that an organization has. Particularly for this seminar, we are focusing on the obligations of private organizations only. So you will hear from both Nina and myself about the different obligations that private organizations, small and large, have under AODA. So the AODA is the act, and it has regulations which basically are the integrated accessibility standards. This regulation sets, like I said, sets forth the framework as to what the organizations must comply with to ensure that they are participating in making Ontario fully accessible by 2025. I'm going to turn it over to Nina now, who will spend some time talking about the different integrated accessibility standards that are formulated under the AODA. Nina, over to you.
Thanks, Shefali. If you could just advance to the next slide, and we're ready to go. So in this lovely slide, you see kind of how the AODA works. So in the center, you have the framework legislation, which is the Accessibility for Ontarians with Disabilities Act. And then you have a number of regulations that provide you details. The integrated accessibility standard actually covers 5 areas, which is if you do it from like clockwise, the built environment, the design of public spaces, which could be parking lots, picnic areas, trailways, sidewalks. So it's the physical environment outside, if you will, that is accessible to the public. You have the employment standard, and we're going to actually put a lot of time on the employment standard because there are a lot of significant requirements, and they apply to every employer in different ways. We have the customer service standard, and we'll spend some time on that because that applies to every employer. There's a transportation standard, which is public transportation. We're just going to mention it, but we're not going to deal with it because that deals with very specific employers and corporations. And finally, the information and communication standard, which applies to differing degrees to the various classes that Shefali mentioned earlier. And so one way of looking at it is the Human Rights Code, which I think most of us are familiar with, provides a complaints-based mechanism for dealing with human rights issues. The AODA is trying to get away from that complaints-based system to a more proactive standard setting that removes barriers universally. So people don't necessarily have to ask for accommodation because it is already there. And the analogy I like to give people is that we take it for granted that there are curb cuts that allow wheelchairs to cross roads. Well, that was a design feature. So instead of somebody in a wheelchair or scooter having to ask the municipality to put in curb cuts, we just proactively designed the sidewalks in that manner. That was not always so. So the first standard, as I alluded to, was the customer service standard. Now, I actually don't like the name of the standard because customer service standard makes it sound like it's a standard that's applicable only to people who have external customers. And that was the case when the standard was first introduced over a decade ago. But subsequently, the standard was modified so that it actually applied to everyone. So anybody has to take the customer service standard training. Everyone has to have a customer service policy. And what people often forget is if you think about the customer service standard as essentially how to treat people with disabilities standard, it should really be, all of us should be trained. And even though it says customer service standard, remember, everybody deals with the external world. As lawyers, we deal with clients. As clients, you deal with us as lawyers. So that is an example of an interaction. If I had a disability that needed accommodation, you would have a policy and I would know how to ask for that accommodation. Next slide, please. Okay, so what does it mean? Hang on, I'm just, for some reason, I've lost my share screen, or if I could get the next slide, I don't know if I'm having a problem on my side or somebody else's side. All right, so I think we're having technical difficulties, but Shannon is jumping in. So what does the customer service standard, let's see, slide 12, thank you very much. What does the customer service standard, however badly named, entail? It requires you to have policies, practices, and procedures with some of the obvious things that we associate with disabilities, including the right of individuals to use assistive devices like canes, wheelchairs, tablets, text-to-voice, voice-to-text mechanisms. It allows people to bring in registered service animals or into all places except for very few areas, and these are areas where animals are excluded due to health and safety requirements. It requires you to have policies with respect to support personnel into your business, and this particularly applies to the restaurant industry, the entertainment industry, and transportation, where a support person might be needed to bring people in or accompany people while they are availing themselves of your services. It imposes obligations with respect to communication, feedback by customers with disabilities, and responding to that feedback and providing information in an accessible format on request. Now, one thing that people often forget is the obligation to provide if there's a temporary disruption to service, to advise people of that. And what does that mean? There's a lot of things that able-bodied people take for granted, such as elevators, escalators, wheelchair accessible doors, accessible parking. If those things are temporarily disrupted, it doesn't make a difference to our lives. But imagine if you are using a walker or in a wheelchair, or you're visually impaired. It may make it impossible for that person to properly access your business, and therefore you have to give notice to people in a way that's appropriate about that disruption. Now, that notice could be something that's posted on your door saying, these wheelchair accessible doors are not working, they're being repaired, they will be back in service in a week, but there's another door available, 20 yards to the left, or call, your cell phone to have assistance, or if you know about a problem, you can even say, we can meet at your place. Now, a lot of this is really written for the pre-pandemic and the post-pandemic world, but nonetheless, it's an obligation that's often forgotten. And as I alluded to earlier, you need to have a feedback process so people with disabilities can reach you. With the advent of email, text, chat, phone, mail, many of us already have all of those accessible feedback processes as part of our normal processes. Most importantly, there's an obligation to provide training to all your employees. And that's extremely important. And the good thing about this training is that there's actually free training, and we'll give you those resources at the end of our presentation that you can adapt and use without cost, so that you can provide this training. And finally, you have an obligation to notify your public of your policies. If you have an internet site, you can use that. Or many people just post their policy right in their reception areas. Of course, that too is for the pre and post-pandemic world. Next slide. So I wanted to really talk, so I talked about the customer service standard. That the next standard that I think people on this call should really get some familiarity with is the employment standard. Now, employees are impacted, or employers are impacted by a number of pieces of legislation, many of which do have an equality and inclusion focus. So here you can look at the Employment Standards Act, privacy legislation, and the common law of wrongful dismissal and unemployment law. What we're talking about today, right at 12 o'clock, the AODA, of course, the Ontario Human Rights Code, workers' compensation, or WSIB in Ontario, and the Occupational Health and Safety Act. So all of these pieces of legislation have been created to essentially protect employees. And I will tell you that they don't always fit together in a perfect jigsaw puzzle, because they were enacted at different times by different regimes. And so while they are consistent in their philosophy, sometimes in a logistical way, they don't always work the best together, but we do the best we can. So if we could go to the next slide, please. All right, I'm just going to try to catch up with my notes. So looking at the employment standard, I'm going to turn it over to Shefali. Yep, she's back online, it's great, to talk about how the employment standard really works and to whom it works, and how it really governs the life cycle of employees with your organization.
Thank you, Nina. Okay, employment standard. It's probably the most important standard for all employers in Ontario, because it sets out different sets of obligations that employers are required to comply with, including written obligations, ongoing obligations with respect to a potential candidate that you're looking to hire, all the way until the end of the cycle, and that person is no longer an employee. So who does this employment standard apply to? It applies to all prospective hires and employees of your organization. It does not apply to volunteers or other non-paid individuals. And like I said, it applies to different aspects and facets of employment. It starts right at the beginning when you're looking to hire the prospective candidates, when you're trying to have your job postings up, or when you're preparing job offers that you will offer to prospective hires. It also applies to situations where you have employees who've gone off on some sort of a illness leave or a disability leave, and also employees who are returning back to the office or back to the workforce from that disability or an illness leave. As well, it applies to all aspects of employment, including disciplining employees, whether there are promotions, if there are internal transfers within the organization, and last but not the least, a reduction in force. So how does this standard apply, and what are the obligations that are applicable to the employees? Going to my notes here. Okay, So the different obligations, employers are required to provide accessible processes for recruitment, assessment, and selection. What that means is that, for example, in your recruitment, on your job postings, you need to ensure that it's noted that accommodation is available on request. And in further, you need to notify during an interview process that there is accommodation that is required for assessment or testing if requested. The employer must also engage the applicant to discuss and find the desired accommodation for the illness or disability. On hire, you as an employer must ensure that new employees are made aware of certain policies, AODA-related policies during onboarding, including the ability to create accommodation plans. This is important because what AODA is trying to set is it's trying to set an expectation between the employer and the employee that the employers will work in tandem with any requirements that the employee may have, whether now or later in the future. And the employees are encouraged to come forward with those requirements that they have with themselves and make it known to the employers so that they can help them cross that barrier easily. Now, with respect to, and then there's an obligation about providing emergency response information as well. This information must again be provided right at the front. When you're hiring employees, you need to ask if there is any requirement to provide any emergency forms. If there are employees who come forward and share with you that they have certain forms of, they need certain type of assistance in case of an emergency, then as an employer, you are required to put together an individual emergency response form and keep it on file for that employee. Again, when you're trying to create these individual response or individual accommodation plans, keep in mind that there is no, it has to be an individual approach. It can be a template that's being used, that is being used for employees on a back-to-back basis. But one employee's needs will be completely different from another employee's. So you have to always start at the very beginning and ask all the right questions and all the questions that are required for an employer to understand what steps it needs to take to ensure that the employee's requests are being met. Next, of course, the employers are also required to provide accessible formats and communication supports for employees. What that means is basically providing, and we'll talk about it later in the next slide, but it's basically providing documentation maybe in a large font if an employee requires that I need something printed out in a large font or something printed out in a color format. So those are like the most basic and simple examples of accessible formats and communication supports. I spoke briefly about documented individual accommodation plans. We'll get deeper into it later on in the presentation, but that's one of the obligations that I wanted to highlight. And of course, we will also talk about the return to work processes. Moving on. Okay, so let's look a little bit more closely at what the recruitment, assessment, and selection obligations are. Like I said, we as an employer need to make sure that you're letting all prospective candidates know of the availability of accommodation for all applicants. Selected job applicants must be notified that accommodation is available in relation to materials or processes followed. This is basically letting them know that you have policies in place, which you will share with them once you're selected. Successful applicants at the time of hiring must be notified at this time of the policies relating to accommodation. Examples of recruitment would be on job postings. You need to ensure that it's noted that accommodation is available. So let's look at the example of a job posting. Here's an example. And of course, this is a very generic written language. You can, of course, adapt it based on the style of the organization. As long as you're able to portray that there's some form of accommodation that will be made available to employees, that is the goal. So let's read what the job posting looks like. We're committed to integration and equal opportunity. Accommodation is available to all participants upon request throughout our recruitment process. Please contact Brad Pitt at 1800 number or email at bradpitt@hollywood.com if you require accommodation. We will work with all applicants to accommodate their accessibility needs. So it's as simple as this. It could be right at the bottom of your job posting or right at top, depending on how you want to portray it. But this is something that needs to become part of your job postings going forward if you've not already done so. Okay, so other obligations include making available supports to be communicated as soon as practicable after an employee starts work. What this basically means is that supports that individuals with disabilities may need to access information. And like I said, this could be plain language. It could be sign language interpreter, reading the information out loud to a person who has vision loss, adding captioning to videos, using written notes to communicate with someone who's hard of hearing. One thing very important to note is employers must always consult with people or employees to provide a range or arrange for provision of accessible formats and communication supports for information that is particularly needed in order to perform the employee's job and for information that is generally available to employees in the workplace. Remember, like I said, it's not one size fits all kind of a solution. So we really need to get into the weeds and need to understand after talking and after discussing with the prospective hire of the employee as to what is it that they really need for the employer to provide that accommodation. Okay. So that brings us to the next topic, which is the individual accommodation plans. I'm going to turn it back to Nia now, who will spend some time talking about the individual accommodation plans that will be required for the employees. Over to you, Nina.
Thanks, Shefali. So what is an individual accommodation plan? An individual accommodation plan is essentially a written record of how you are going to accommodate an employee who has a disability. Now, this obligation, it's very important, really dovetails with your obligations under the Ontario Human Rights Code and also under the Workplace Safety and Insurance Act to accommodate employees with disabilities or illnesses. But the AODA standard only applies if you have 20 or more employees in Ontario. Essentially, you have a policy. You need to have a policy if you have 20 or more employees about how people will ask for accommodation, how that policy will be, how that request will be processed and considered. And once you have essentially come upon a solution, you will write up the solution. You will actually sign it and provide the employee to at least sign it. And most importantly, you should review it periodically. This obligation sounds very complicated, but in fact, it just codifies our obligations as employers under the Ontario Human Rights Code. I actually find that the obligation to put things in writing, record it in writing, and review it periodically, not less than a year, actually prevents human rights problems from occurring. There's a famous case in which an employer was slapped with an award, almost $1 million, or more than $1 million after everything was added up, because there was a dispute in the evidence as to a particular conversation. That is not going to happen if you write it in writing and get it signed and periodically review and update it. So I actually encourage all employers, small and large, to really consider having robust policies with respect to how accommodation is dealt with, and ensure, of course, that your employees know about it. There's a note at the bottom of the slide about how this applies to return to work scenario. If you read the regulation, it almost sounds like you need to have two separate policies, one with respect to individual accommodation plans, one with respect to the return to work policy. In my view, the return to work is a subset of all accommodation plans. And so I would say that you may wish to really consider integrating your obligation to have a return to work policy with your general policy on IAP. It's just what your preference is. Next slide, please. So, as I've indicated before, it's the discipline of writing things down in writing. Now, one thing that is really not a AODA concept, but it is a human rights concept, and it lives in the AODA as well, is accommodation is the point of undue hardship. You are not required to provide the employee his or her preferred accommodation or the optimal accommodation. It has to be reasonable accommodation. Once the employee is put on an individual accommodation plan, you are entitled to have reasonable expectations of performance. But here's something I warn you about, is that accommodation is a bit of a trial and error process. And there is a requirement, if you first don't succeed, to try again. So I've seen too many employers in my career say, well, we tried that and it didn't work, so obviously we can't accommodate. Increasingly, both under the Human Rights Code and the AODA, employers are expected to really make a good faith effort to try to make it work and use the accommodation process as a way of truly integrating a person with a disability into the workplace, as opposed to shrugging your shoulder and saying, well, that didn't work, so we're not going to try anymore. There are some detailed expectations under the AODA that we should look at, which is we have to integrate two things that Shefali mentioned before. One is the individual emergency response plan. So think of an employee perhaps who is not able to navigate stairs in order to exit your building in case of an emergency. What is the plan if there is a fire or other evacuation? What are you going to do? Now, typically what fire marshals will tell you to do is have a staging area so the first responders know to go there first. That's an easy solution, but let's make sure everybody knows about it. The other thing is accessible communication supports may be required. So for example, employee may need a larger screen in order to blow text up, may need some help in text to voice, voice to text in order, or may need confirmation of things in emails because they have a cognitive issue and it's easier for them if instructions are provided in writing so they can review it periodically through the day. Those kinds of supports should be actually cross-referenced in your individual accommodation plan. It doesn't happen too often, but it happens enough that you need to remember to do that. And of course, if you have a formal policy, it's going to be one of the things that are checklisted right away. So as you proceed to the next slide, you will see the information and communication standards. Now, parts of this standard applies to every workplace in Ontario. And essentially what it says is if you get a request to accommodate a customer or an employee or a service provider on request, you should have to accede to that request for accommodation. Now, I've been doing this work ever since the AODA was enacted. And this is not as high or imposing a standard as it looks when you read it in the legislation. Typically, the response is to provide a document in a PDF or Word version so that people can use text to voice. So That's one common request. Occasionally, you will have a request for a complicated graph or chart to be explained orally because somebody can't read the chart or read the graph properly. There's some excellent courses available on essentially drafting communications in an inclusive manner so that your document or your communication or your website page already has built in a lot of the techniques necessary to include a large portion of the community that has some form of disability or barrier. So if you look at to the next slide, the reason why I don't think this is a high standard is it's really typically triggered by on request. So even though I talked about techniques to make your communications accessible to a large swath of the community with disabilities, it's actually not, it's best practices, but it's on request to provide accessible formats and communication supports. You should have an modalities to provide feedback that broad swath of people with disabilities. And as I said earlier in my presentation, many of the multimodal techniques we already use, text, smartphones, emails, phone, really lend themselves to the current technology. Now, one thing people forget is emergency procedures plans or public safety. If you provide public safety information, so, for example, evacuation information, emergency contact numbers on request, that information has to be provided in an accessible format. What's accessible? That's a conversation with a person making a request. As I've said earlier, the two most common is some kind of Word or PDF format so they can use their existing technology, or alternatively, a verbal explanation of information that is on a printed page. So if you go finally to the next slide, we have the information and communication standard, the one that's a little bit more complex. And this is your websites. So this obligation really is applicable if you have 50 or more employees in Ontario, and you directly, your organization directly or indirectly controls the website. We've had a number of questions, quite frankly, about subsidiaries of foreign multinationals who actually, now they may have a Canada webpage, but they actually don't control the website. They're a service provider or distribution entity, but they don't have much say on the website. That's a factual issue. If in fact, you can say, look, put this on the Canada page, then you at least should make an effort to make the Canadian pages comply with the standard. And what is the standard? It's the standard established by the Worldwide Web Consortium, which is a non-governmental voluntary organization that creates standards for web content accessibility. And they're often called WCAG, just because it's a big of a mouthful, that WCAG. And the standard to which you're held in the legislation is 2.0 level AA. And there are some exceptions for live captioning and audio descriptions of photographs and stills. Now, just so you know, the actual WCAG organization is working on a 3.1 standard. So businesses should actually try to implement these best practices as a matter of course, but there is a legislative obligation in Ontario to meet the 2.0 level AA standard. There are some defenses, including where it's not practicable, but as many people will tell you, there is no case law which will tell us what is or is not considered to be practicable. Since January 1, 2021, all websites that are caught by this standard must comply with that level AA standard with the two exceptions regarding live captioning and audio descriptions. If we could go to the next slide, please, Shannon. We're going to go into policies and training. And I don't want to make this an infomercial. There's lots of great policies and training out there. And of course, you have to pick what's right. But if you're struggling to find something, don't hesitate to reach out to us. We will find you either a good public resource or referral, or develop something customized for you if that's what you want. And Shefali delivers a lot of that training. So I'm going to dump this all on you, Shefali.
Sure. Okay, so let's get into it. So let's talk about the policies and training. This is the written obligation for employers, and this is probably the way employers are able to show in case of an audit that they are compliant with AODA and their obligations under AODA. Now, let's talk a little bit about what these written policies are, and then we'll get into the training obligations. First and foremost, AODA requires, and the integrated accessibility standards require, that all organizations to which AODA applies have an accessibility policy. Now, what is this policy? It's really a roadmap that provides brief information about what are the different steps or the different policies that the employer organization or the organization has taken or put in place to meet with its obligations under the AODA. So for example, let's take the example of a large organization, which is defined to be an organization which has 50 or more employees in Ontario. Those organizations are required to comply with the full extent of the written obligations under AODA, which means all policies must be put in place, implemented, established, and put in place in writing. So your accessibility policy will actually talk about, it'll have a statement of commitment, and then it'll have simple paragraphs about each of the policies that you have put in place that specifically deal with the different aspects of the integrated accessibility standards. For example, it'll say we have put in place a customer service policy. Please refer to our customer service policy for more information about how we deal with customers. And then it'll talk about, we've also implemented a multi-year accessibility plan, which talks about all the different steps that we've taken so far and what we will continue to take in the future to ensure that we meet with our obligations. And then it'll also talk about if you've implemented a feedback policy, if you've implemented an accommodation and a return to work policy. So that's what your accessibility policy is. It's a very simple document. Again, there is no specific template that's been provided. As long as you hit all the basic or the foundational aspects that are required under the integrated accessibility standards, it can be drafted in a way that works best for the organization. Now, the requirement to have a written accessibility policy, interestingly, only applies to large organizations, which is organizations which have 50 or more employees. But the problem that we always have with that requirement is that if you do not have a written policy, you still need to establish a policy. So when you have an audit and you have an auditor or an inspector asking you, have you complied? Have you established a policy? You'll say yes, but when you have to show compliance, it's really hard because you have no written document to actually show that you put in place all of these policies. So our recommendation is, regardless of whether you're a large or a small employer, the minute you have obligations under AODA applicable to you, as a best practice, it's better to just go ahead and put in place at least the basic policies, which is accessibility policy is a basic policy, just to show that you are doing your bit to be compliant with AODA. Now, next is the multi-year accessibility plan. Now, this one specifically only applies to large organizations, and this must be in writing. And the requirement is that it must be updated on a 5-year basis. And again, so multi-year accessibility plan is something that tells an inspector or an organization who is auditing you, that is the Accessibility Directorate, to tell them what are all the steps that you've taken in the past to ensure that you're meeting with your obligations. It also talks about the steps that you will take in the future to continue to meet those obligations. So it should ideally address every single aspect in the integrated accessibility standards, and it should speak about the steps that the organization has taken, will continue to take. That includes implementing policies, providing training, how are you dealing with your obligations under the Employment Standards Act with respect to hiring employees? How do you deal with the obligations when you're transferring employees, or whether the reduction in force, and your feedback policy, etc. Now, the important thing with the multi-year plan is it is a public document, which means that it is public facing, and you have to keep a copy of it available to public. If you have a website that you own and control, you are required to post this policy on your website. If you don't have a website, or you don't own or control it here in Canada, then you're required to keep it at a reception area or a desk area, where if employee or if service providers or public walk in and ask to see a copy of it, you must provide it to them. Same with the accessibility policy. Well, the legislation doesn't specifically spell out that it must be posted on your website, but it goes hand in hand. It always shows. It's always good to put it up on the website if you have one, or to keep it, or in any event, you should keep it available, make it available at the reception area, and provide it to public on request. Next up is the customer service policy. Now, this is a requirement that is coming out of the customer service standard, which says that all organizations to which this standard applies must establish and put in place a customer service policy. Similar to the accessibility policy, the written obligation obligation to implement a written policy only applies if you are a large organization, but the same advice applies with respect to best practice. So it is very difficult to show compliance if you don't have a written policy. So you might as well just put in place a policy for customer service. The aspects of a typical customer policy are how do you deal with individuals who need assistive devices? How do you deal with individuals who walk in to your establishment with a service animal? How do you deal with people when they walk in with a support person? So those are some of the examples of the different aspects that your customer service policy must address. Another important aspect, which Dina mentioned earlier on, is with respect to temporary disruption. So what it does is that the customer policy must specifically address or talk about what steps will your organization take in case there is a temporary disruption, and speak to the protocol as to that you will put in place in case of such temporary disruption. So that is another mandatory policy that you need to have if the AODA applies to you. Next up is the feedback policy. It's really, so feedback policy comes under two separate heads. One, there's an obligation under the customer service standard itself to have a feedback policy in place that will basically tell public or employees or anyone who's reaching out to the obligation to provide feedback, to reach out to them and let them know that you will come back to them within a certain reasonable amount of time frame, and give them phone numbers, email addresses, or physical address where they can come and actually provide that feedback. So that's one obligation that's coming out of the customer service policy. So that could actually be addressed as part of a customer service policy. Then there's a separate aspect that falls part of the information and communication standards. Now that obligation really only applies to you if you as an organization have put in place a feedback process, like in the sense you're allowing customers or public to provide feedback to you. Then it says that then your feedback policy must also address what steps you will take if these customers or public who are coming to provide feedback request that they need to provide feedback in a more accessible format. So that is what your feedback policy will address. And again, feedback policy, customer service policy, multi-year plan, accessibility policy, all of these policies are public facing, meaning this must be made available to public if they request. Now, coming to the next one, which is the accommodation and return to work policy, this is really an internal policy. The requirement to implement a written accommodation and return to work policy, again, falls strictly on large employers, but really, like, we recommend that this is a basic policy that is required when you need to implement individual accommodation plans, which is very important from human rights as well as the AODA perspective. And it really provides you with the opportunity to lay down the steps and lay down the responsibilities vis-a-vis employees and employers to say, what do you need to do if you need to ask for accommodation? What are the steps that the employer will take when you ask accommodation? So that makes it clear, and it's really good to have. And it doesn't need to be made available to public. Of course, if auditors of the accessibility directorate ask for it, then you have an obligation to provide a copy to them. But otherwise, it's more really an internal document to the company, which the HR relies on to follow the accommodation process. Now, that's with respect to the policy aspect. And these are the basic policies that you need to have, and this to ensure that you are complying with your obligations under the AODA and the integrated accessibility standards. Now, next, moving on to the training obligation. This is an interesting one because training currently, as it stands, must be provided to all employees of the organization and volunteers. Originally, when the training obligation was introduced, it was only with respect to training employees or volunteers who were customer facing or public facing. But I think later on, in I can't remember if it was 2015 or 2016, this obligation was expanded and it was applicable to all employees. And really, I think that that falls back on the foundation of AODA, which is basically to provide access to everybody and not just to people who are seeking customer service. So anyone who is working for an organization needs to understand certain basic things about how do you deal with individuals who need some special care or individuals who require a different touch when you are providing services or when you are hiring. So training must be provided to all employees and volunteers, including persons who participate in developing your policies. Now, I wanted to touch upon a little bit upon the aspect of persons who participate in developing your policies. Oftentimes, we have questions that come up and say, I have a unit who's sitting in Alabama who's working on these documents for us. Does it mean that we need to provide some sort of a training to that person who's helping us create those policies? Well, simple answer to that is yes. The training really is not a lot. And like you'll see in the next slide, there are free resources that are provided. And it's really for, it's really important for people who are participating in creating training materials to understand what AODA is trying to achieve. And without that understanding, it really doesn't help that the training is being provided with someone who doesn't understand the foundations of AODA. So yes, the training must be provided to all individuals who are participating in developing your policies. And lastly, all persons who provide goods or services on behalf of the company must also be trained. So what does the training entail? So there are two heads of training under the AODA. One is the basic training itself, which is the training on the different integrated accessibility standards, meaning, the different standards about the employment standard, customer service standard, information and communication standard, transportation and built design, and also the fundamentals of Ontario Human Rights Code. Like we discussed earlier on in this presentation, AODA works in conjunction with the Human Rights Code. It implements the foundations and the concepts that are enshrined in the Human Rights Code. So it's really important for all individuals to understand what those basic fundamentals are with respect to what constitutes a disability, what is the concept of accommodation, because accommodation is up to a point of undue hardship. So basics of human rights, so that is one part of the training. And that's the general training that must be provided to all employees and volunteers and persons who participate in developing your policies and persons who provide goods, services on behalf of the company. Then there's a second set of training, which is an obligation that's really coming out of the customer service standard. Now, again, customer service standard training, like Nina mentioned, it's a badly named legislation. It says customer service standard, but the training really must be provided to all employees, regardless of whether or not you're providing service to customers. And this is really the basics of how do you interact with people who have who walk in with a service animal. Basics like don't pet the animal. The animal is not there for recreational purposes. It's actually doing a job. How do you interact with people who have vision impairment? How do you interact with people who come in with support persons? That's the kind of training that customer service focuses on, and that is the type of training that must be provided to all employees. So that in a nutshell is the obligations for training for all organizations. Now, with respect to training, there is also an obligation to maintain records of those trainings. Strictly speaking, maintaining records is not applicable to small organizations. But again, same recommendation applies. If you don't maintain the records of the training, it's going to be very difficult for you to show that you actually did complete the training for all the employees. So that is with respect to training. And moving on. So on this slide, you'll see some of the free materials that Ontario Human Rights Code provides with respect to the human rights aspect of the training. This is really the basic, and as long as your organization is able to utilize this training and provide it to all your employees, you're at least meeting with the aspect of the general training requirements. Again, it meets with all the basic requirements under the AODA, but of course, if you have a specific flavor or if you want to customize it more depending on how you want to provide that training to your employees, you can definitely go ahead and modify that training. But for the purposes of meeting your minimum obligations so that you're able to check that off on your compliance report saying, yes, we've completed that training, this is an excellent resource. And on the next slide, you'll see another option for free training, Access Forward. So this is a little bit more detailed than the Ontario Human Rights Code training, and is a really good resource, has been prepared by the Government of Ontario to help companies ensure that they're meeting with their training obligations. So Access Forward actually has the main, both forms of training. It has the customer service training as well as the general training under AODA, which is with respect to the basics of AODA and the integrated accessibility standards, as well as the Human Rights Code. So these are two free resources that are available to everybody, and they can be leveraged and to ensure that you're meeting with your training obligations under AODA. So, okay, so that brings us now next to our hot topic as to why we're having this seminar today. That is the compliance report. And over to you, Nina.
Yes, there's an exam on or before June 30th, and we're all swatting for the exam. So one thing, can I just mention on the compliance report, on the training, you will have seen the Access Forward materials. They actually have techniques where you can embed their units into your own learning and development programs. And they've essentially given a license to anyone to use their materials, provided that there is an acknowledgement. So excellent resources. Even though it does not do the customer service training, that basic training that, it was required since, a decade ago, it really gives you great start on all of the other training obligations. So I'm a real fan of that site. So going to the compliance report, if we could go to the next slide, please. Maybe I could, yes. All right. So who has to comply? And we got this question in the Q&A, and I didn't answer it because it's companies with 20 or more employees in Ontario. So if you have 20 or more employees in Ontario, and that does count part-time employees, so you will have to file a compliance report. Now, the compliance report that you file when you are 20 to 49 employees is a different one than if you have 50 or more employees in Ontario. And the purpose is really to ensure that you have met your accessibility requirements under the AODA. Now, typically, the timing was every 3 years. And I mentioned earlier that the last filing deadline was December 31st, 2017, when the government servers crashed. Should have been December 31st, 2020, and extended to June 30th, 2021, largely because of the pandemic. And what we don't know is whether or not the next filing deadline will be December 31st, 2023 or June 30th, 2024. We'll see. We still live in a pandemic world, and a lot of things are uncertain. So if we go on to the next slide, you'll see some of the information that we need to have in order to file your report. And there will be questions about your compliance with the customer service standard if you are between 20 and 49 employees in Ontario. However, if you're a large organization in Ontario, 50 plus, you will have questions regarding all of the integrated accessibility standards. And we won't have time to go through the entire questionnaire, but I'm actually going to try to queue up and steal the screen from Shannon and queue up my screen so you can see a little bit of what it looks like. To complete the report, if you could go to the next slide, all filers, so 20 plus, will require some basic information. You will need the full legal name of your entity. You will need the business number, that's the Revenue Canada number that's given to you. You will need to provide the total number of employees that are in Ontario. You have to provide a name and contact information of the certifier, and that person is going to be the person who says, I'm confident this report is accurate and complete. It's often a senior HR operational person. It does not have to be the CEO. And you can file for up to 20 organizations. So if you're a large organization that has lots of related employers or companies, if they're the same size, so 20 to 49 or 50 plus, you can actually file for up to 20 organizations at once. So essentially, you just keep adding their business number and legal name, and adding their business number and legal name, and you keep doing it at the same time. So that's something that not a lot of listeners will have to do, but it can be a helpful thing to know. Now, I'm going to try and see if I can share my screen. If Shannon, you could stop sharing your screen for 1 second, that would be great. I will try again. All right. So hopefully what you see, and somebody shout out if you don't see it, is a document that says AODA Accessibility Report. And because the large employer has more obligations, I'm actually going to take you through that one. And it's not easy to do online because they don't let you see the questions unless you file. So actually, we pretended to file for Gowling's in order to get all the questions and replicated the exam, if you will. Now, this form starts with B because Form A is really inputting the name of your company, the business number, and who's certifying. All right, so this is the stuff that I haven't gone through. And essentially, you can see how the questions work. It starts with, does your organization have written accessibility policies and a statement of commitment? It should be yes. I'm hoping that all of these questions you'll be able to answer yes. And if you can't,
Nina,
yeah.
Sorry to interject. We can't see your screen. We're only seeing a screensaver.
Oh dear, that's very sad. Okay, let me try one more time. And if this doesn't work, I'll just stop doing this. We keep trying. Yes, I am on the screensaver. Bad girl. Okay, let's try this. Did that work any better? No.
It does, yes.
It does. Okay, good. All right. So I will thank you very much, Shafali. So you'll see that we started at B because we assume that you put in who you are and who's certifying your business number. And we're going to start your accessibility requirements. And you'll see you'll start with, do you have a written accessibility policies and statement of commitment? Say yes. If you don't, you make sure you are yes by the time that you actually get to it. And if you are struggling with it, reach out to us and we can actually help you, or you can actually we can refer you to resources. And then it says, well, have you done your multi-year accessibility plan? You heard Shafali talking all about that. Remember, this is a large employer one. You won't be asked these questions if you are 20 to 49. Do you provide training on the AODA Integrated Accessibility Standards Regulation and the Human Rights Code, right? And are you generally compliant? Are you complying with the customer service standard? And then it goes to information and communication, and it goes to emergency procedures. I'm not going to go through all the questions. It's very boring to do that. Are you generally compliant with the information communication standard? Has some very detailed questions about your employment practices. You can see that here. And we're going to send you this, so don't worry about trying to scribble everything. We're sending you a number of very helpful tools to help you get compliant. Now, some people have said, well, what do I do if it doesn't apply? So the one that often doesn't apply to people is the design of public spaces, all right? And the question is, since your organization submitted its most recent accessibility compliance report, has your organization constructed new or redeveloped existing exterior paths of travel? So that's like sidewalks and paths that it intends to maintain. So if you're, a tenant like we are, and it's really the landlord that does all of that, it actually is the landlord's filing that will cover it, not yours. You will be responsible for the portion that you've leased in terms of its accessibility, but not the exterior paths of travel. When you click no on that survey, if that's what the right answer is, those questions disappear. So 13A would disappear, right? Similarly, you'll be asked questions about public use eating areas. I can tell you that our own office in Waterloo, they put in a whole bunch of picnic tables and stuff pre-pandemic, I might add. And of course, that would be the landlord's report, not our report. So once we press no, 14A disappears, and so on and so forth. Outdoor play spaces, same thing. Accessible off-street parking, same thing. And you will see that those are ones that probably your landlord has to fulfill. If you're a landlord, real estate developer, you will have to deal and grapple with your obligations under the design of public spaces standards. Now, somebody asked a question about, well, what's our accessibility standard if, we lease space? And the biggest one in this area is your service counter, your reception desk. So if you have updated your reception desk, which we did about 3 years ago, we actually have to make sure that we have an accessible reception area. And that has there's some requirements in terms of making sure we have room for wheelchairs, scooters, and walkers, but also that we have a lowered service counter. And you see this quite often at banks, so that a person using a scooter or a wheelchair can make eye-to-eye contact with the receptionist. So that would be one that many office or tenant people will have to grapple with. One thing I note is that if you're ever using an interior designer or an architect, they often just automatically comply with the AODA requirements as a best practice. And then you'll see the questions on waiting areas, which I've anticipated, and then you get a generic-ish questions. All right, so that really is your exam for large ones. For a small one, a company, you will get a very small questionnaire that really deals with your customer service standards. We will send you the exam questions, and we will clearly identify which exam questions, as I call it, apply to the small organization, which is 20 to 49, and which applies to 50 plus. And if you are that 1 to 19 category, so you're a smaller entity in Ontario, then you don't have to file. But as Shefali has indicated, there are some best practices that we would encourage you to consider. So I'm going to assume that most of you are compliant, but there are some consequences for non-compliance. And I would invite Shefali to essentially take us through the next slides, which deal with some of the fines that are available under the AODA legislation.
Thank you, Nina. Okay, so issues with non-compliance. Well, so far, we're of the view that the government is appearing to use a nurturing approach to ensuring compliance with the AODA. While AODA has some harsh maximum penalties, the integrated accessibility standards actually softens the blow with substantially lower monetary penalties before the maximum penalties can occur. As you can see on the screen here, the maximum daily penalty of $100,000 for corporations and $50,000 for individual or unincorporated organizations comes out of the Act itself. But under the regulations, the Accessibility Directorate has gone ahead and explained as to what are the different categories and what are the different types of contraventions that would occur based on which the fines would be categorized. So the contravention, the penalties and fines will really depend on the severity and the history of the contravention. The director will determine the severity of the contravention by ranking the contravention as minor, moderate, or major. So as you can see, there are different buckets. For minors, it's 2,000. For moderate contravention, it's 1,000. And for minor, it's 500. So minor, quickly touching up on what constitutes minor, moderate, and major, where there's been no more than one previous contravention within the period of two current reporting cycles. That's a minor contravention. And modern, where there have been 2 to 5 previous contraventions, that's moderate, and major would be where 6 or more. And based on our experience, we've seen that Accessibility Directorate, the directors are really looking at finding where there's been a total failure of compliance, where a company has had over 50 employees for the last 10 or 15 years, and they have failed to comply with basic obligations under AODA. And of course, decisions will be made on a case-by-case basis. And the next part of the issue with non-compliance is the reputational damage. Nina, sending it over to you for the reputational damage.
So, okay, so if Shannon, I'll let, I am trying, okay, I'll try to start my video there. Just as we were preparing these slides, Shefali, I saw this article about a woman who has spina bifida and uses her forearm crutches to get around. And she was prevented from using a washroom that is downstairs because the server felt that it was too dangerous for her to go down. And if she had been properly trained under the AODA, she would have known that the appropriate thing is, can I be of assistance? Or, if you're not comfortable with the stairs, we've made arrangements with the business next door that has a level access to washrooms, but not preventing somebody. And incidentally, I had a friend who was in a very similar situation. You would be amazed how well she did with crutches. So this reputational damage is horrible. It's a small restaurant in Toronto, and it's really on the front page of the Toronto Star for being bad to people with disabilities. Nobody needs that kind of coverage. So we have had tons of questions, and we realize that we are short of time, but I did want to take a few questions. And Elisa, I think in the interest of time, what I'm going to do, if we want to go to the question slide, is I'm just going to read some of the questions. And oh, yes, I should do some tips. Yes, please, no last minutes, please, because of that. Reach out if you need help, and we're going to send you some great tools so you can do some self-assessments and really identify where you may have some concerns. So I know we have a few minutes and to deal with questions. And I think we've actually dealt with a whole bunch of them. But I'm going to just go through some of them. There's a couple of questions with respect to mental illness and whether that constitutes a disability. And we are in Mental Health Week. And in fact, mental health is absolutely recognized as a disability, cognitive disabilities. It could be acquired brain injury, it could be depression, but all of those are recognized as disabilities. And so that's a common question. We have an excellent question about service animals. If you don't have customers, you should absolutely still allow service animals for employees. So that should be part of your policy. Elisa, are there any other questions that you think that we should address that I've missed?
I've seen a couple on the training policies. I wanted to quickly address that. I think there's a question there about, can you club all the policies into one? We would not recommend it, especially if you're a large organization. It's better to keep your policies separate, especially with respect to your customer policy, customer service policy, and your multi-year accessibility plan. Also, like I said, not all of the policies are public facing. Your accommodation and return to work policy is an internal policy. So if you club it all together, you're going to have to put that on your website as well or make it available. So that's not ideal. And so, yeah, it's not ideal to club it all. If you can, please split it up.
Oh, and there's a really good question in this new world of the gig economy about, what about if we have workers who are working from a placement or a temporary agency? So typically, if people are providing goods and services on your behalf, right? Like, so on your behalf, you have to have them trained. That is a factual analysis. You might want to make a quick call to one of us. But definitely the placement agency or temporary work agency itself will have obligations to provide training as well. So that's, that's often something that is discussed between you and your staffing agency about what kind of training is appropriate. And remember, a lot of this training can be done online via webinar. So we're not talking about a large ask. I'm just trying to look, and I appreciate we're going to have to wrap up in a minute. I'm getting the signal. Oh, one good question is website requirements might not apply to websites behind a passport or an app. So the legislation does not, first of all, apply to that whole world of apps, arguably. That is, I know that the Accessibility Directorate was looking at new rules, and all of that got put on hold due to the pandemic. The other thing that's very interesting that the questioner asked is, what if it's behind a password? So think about a portal where you have to enter your password and then you access, let's say, information. Now, I'm going to talk about banks. They're not they're federally regulated, so they're actually exempt from the AODA. They have other obligations, but not AODA obligations. So the landing page and the password interface itself has to be totally compliant with WCAG 2.0 level A, but arguably everything behind it does not. Now you may have other obligations, which is to provide accessible information on request, but you may not have the actual WCAG obligation. Now, that is something I've been consulted on by many organizations. I've even approached the Accessibility Director. Their answer is, well, that's not consistent with the spirit of what we were trying to do. And my response is, yes, I understand that, but look at your own legislation. So currently, I think that if it is legitimately behind a password, you probably have a defense. Now, again, you have to think about the fact of where the Accessibility Director is going to go, which is to include some of that. I believe, at least I've been told that. And you also have to look at reputational damage. If you have do you really want to be the company that is on the front page of the Toronto Star for not trying to address accessibility as best possible? So I think we're running out of time, so I'm going to leave it there. We realized we had 80 questions. We probably should just do a Q&A on AODA and not present anything. We do hope that we answered some of your questions during our presentation, though.
Thank you so much, Nina and Shefali. That was an extremely informative session, and I hope everyone enjoyed it. As I mentioned, we are presenting a series of 6 webinars. This was the first in our series. Our next seminar is on mandatory vaccinations, a topic I think that's on the mind of a lot of employers. That will be on May 27th. We will be sending out the invitation soon, so please keep an eye out for that invitation. And we truly hope that you can join us for that session. We hope you have a wonderful day and stay safe.
Bye, everyone.